A very good evening to you and welcome to Face the Nation. My name is Bonge Wazwane, standing in for Clement Manyatela. Coming up on the show this evening, we'll look at the NPA after it suffered a legal blow while trying to prove that all was above board when the former Free State Premier Ace Magashule's personal assistant Moroadi Cholota was extradited back to South Africa. We'll speak to the NPA as well as some legal analysts on this particular matter. Also, the MK party has redeployed Floyd Shivambu, but was this a good decision? What implications is this likely to have for the party? Dr. Levindo will answer those questions for us, while the Department of Water and Sanitation will tell us if South Africa is on the brink of a full-blown water crisis or not. All these and more coming up, but first, my comment. While the National Prosecuting Authority is considering its options following a scathing judgment by the Free State High Court that the extradition of Moroadi Cholota from the United States was unlawful, there's a great deal of concern about future high-profile cases. Cholota is the former personal assistant to former Free State Premier Ace Magashule. Judge Phillip Loubser raised a number of concerns about the NPA's handling of this matter.
The prosecution conceded that Ms. Cholota should not have been required to plead to counts 1, 2, 7 and 8, as well as the alternative counts to counts 3, 4, 5 and 6. It undertook to stop the prosecution as far as these counts are concerned. Although it remains a mystery to this court why the counts in question were put to accused number 17 at all in view of the terms of the extradition order, it will not be necessary for the prosecution to stop the prosecution in relation to those charges.
But that was not all.
The state should have made certain of its facts, and in paragraph 166, I agree with the submissions by Mr. Makapela to the effect that the state would provide false, incorrect information to authorities of another country concerning a South African citizen presents a serious public interest concern and has serious implications on the interest of justice. I also agree with his submission that the above conduct by the state grossly infringes an international law and constitutional law.
While the extradition process itself and how it was done was another area of focus, with the court taking the NPA back to the case of the South African-born artist Jonathan Schultz. In this case, the SCA laid bare the functions of the NPA and the Minister of International Relations. It was explicit that while the NPA is empowered to determine who is to be prosecuted and for what charge, if the accused person resides outside of South Africa, then it needs the minister as the executive authority. Yet it seems that this process did not, in fact, happen.
Consequently, I have to find that the prosecution has not proven beyond reasonable doubt or at all that there was a valid and lawful request from the Republic of South Africa for the extradition of Ms. Cholota from the United States of America. It follows that if there was not a valid and lawful request for extradition, then the extradition itself was without any basis and therefore unlawful.
Now, while the NPA says this judgment has no bearing on the trial against the other accused in the Asbestos case, it seems not everyone agrees.
I've said I want my day in court. Because out there in the public, books were written about me. I'm corrupt. I've received 10 million. The charges are still there. Moroadi refused to implicate me. There are many who refuse to implicate me. And in terms of the list of state witnesses, I don't know I so wish even that one who wrote books, Louis Liebenberg, Mayberg might actually be called. In fact, I will ask the court, if possible, to call that chap and to call all those who appeared before Zondo Commission. I've said this case is political, and Moroadi Cholota, and that's why MPA has hidden the recordings. They recorded Cholota for 2 days. There is no way the record did not actually, the tape recorder did not actually work. They knew what they were trying to say to Moroadi Cholota. We still want that audio visual, and I wish we will actually get it. I will surprise the court with some of the audio visuals with time.
The Justice Minister is unsettled.
I am worried, and that's why I say that I've given them 2 weeks to bring all the extradition cases in front of me to be able to look at them and ensure that they comply with the law. So that I will be doing in the next 2 weeks. I've asked the department and the legal team that supports me, that does my legal work within the Department of Justice. I've asked the NPA to submit to them all the extradition cases that are running, both that are before court or that have made applications, to review them all independently together with the team that will support me, to be able to write to those and notify. Remember, in terms of the law, when there's a judgment, for example, the SCA judgment that has been issued previously on the extradition matters, what is required is that we must bring that to the attention of the judges in terms of South African law. So we'll apply that retrospective, we'll apply that in terms of other cases. But I must say that I have already, last month, in the month of May, submitted 2 pieces of legislation to Cabinet for approvals, which have been approved and are going to Parliament to review the legal framework of extraditions in the country.
Now, the NPA has found itself under scrutiny in recent times. Think about the tongue lashing it got from the Timothy Motosha case, which it is appealing. The Nulan matter, where the equality of witnesses also came into sharp focus. Now, the organization is here, which begs the question, how confident is the NPA of successfully prosecuting the accused in the Asbestos case? How concerned is the NPA about its image? Because these are high-profile matters. Should South Africans worry that all is not well within the organization, or better yet, what does Advocate Shamila Batoy, as the head of the NPA, say to the public to restore confidence in her organization? Share your thoughts with us by sending us a WhatsApp voice note on 078-459-1897. Remember to tell us your name and surname and where you are sending the voice note from. Also, please keep it to 30 seconds. Find us on X as well at Face the Nation SA. In just a moment, we speak to Mthunzi Maka, who speaks for the National Prosecuting Authority. All right, let's look at the ruling earlier in the Free State High Court around Moroadi Cholota and her extradition. And of course, this was a special plea by her and her lawyers. Advocate Mthunzi Maka, NPA's national spokesperson, joins us live now this evening for this conversation. Advocate Maka, thank you so much for your time this evening. This morning, you said you were taken aback by the ruling. Of course, a lot would have happened between then and now. Has the NPA had a full day or time to process this ruling?
Good evening, Bongi, and good evening to your viewers. We are in that process of reflecting on the judgment, given the fact that a judgment of this nature has the effect of a final order and therefore is dispositive of the issues insofar as the charges that Ms. Cholota was extradited in respect of and that she was facing, until such time that the prosecution decides to appeal the judgment, and successfully for sure, those charges, at least for now, are in abeyance, in the sense that we can't charge her. So no decision has yet been taken whether we're appealing or not. We are seriously considering if we can identify solid grounds upon which such an appeal can be mounted, given that even on the issue of extradition, which the judge has cited, the Schutz judgment, the SCA pronouncement on the power of the executive authority to make the request, contrary to or in deviation of the past regime where the NPA was the one that actually proceeds or initiates the extradition application. So that is one of the issues that we'll be seriously considering.
And as you seriously consider that one particular issue, then one would ask, because the court earlier saying that it didn't want to deviate from what the SCA would have said in this particular matter, and it seemed that according to what the judge had to say, all was not above board with regards to this particular extradition process. You think about the fact that the Minister of International Relations, according to the judge, is not the one that would have asked for her to come back home, but it was rather an official from the NPA, of course representing the advocate Chamila Batoy in the Free State. How then are you going to be contending with that particular matter?
Let me first clarify the fact that the Minister of International Relations does not get actively involved in the application of an extradition. It is now, according to the Supreme Court of Appeal, in respect of Schutz judgment, the Minister of Justice and Constitutional Development, who is now empowered to make the application. I need to then take you back to say the application was above board insofar as it was made by the DPP at the time Schutz judgment had not been delivered. So when we made the application, there was no pronouncement on Schutz, on the powers of the minister to make the application with regards to the SCA. That judgment came after the NPA had processed the extradition application. And currently we are appealing the judgment of Schutz, albeit on limited grounds, to the Constitutional Court, because the worry that we have is that currently it has retrospective effect, which means it has implications on a number of extradition applications that are underway. And therefore we can't leave it as it is, as it has an impact on how we deal with currently processed extradition applications.
So if I'm hearing you correctly, then you're saying that the judge would have erred in the fact that he said you would have had 2 months, to be able then to engage the Minister of International Relations after the Schultz judgment. So he would have erred because then it would have come after your application would have been made.
I am not in a position at this stage to point out what the judge would have said, which would be a ground for an appeal, given the fact that no decision has been made by the prosecution team whether to appeal or not. We are still in the process of reflecting on the judgment, and tomorrow we'll have further engagements with the prosecution team. We might make an announcement.
But you are saying that the judgment, right, was not in place when the application was made.
Not at all.
So that would mean then that in not so many, words, the judge would have erred in your view. That would be the ground, because then you would be saying that we actually did not have this 2 months that Judge Loubser says that we had in order to be able to engage the International Relations Minister.
Bongi, I'm a lawyer, and the rules expect or require me to use an appeal process to criticize a judge publicly. It would not be proper for me to say the judge erred or the judge was wrong. It suffices for me to say we are reflecting to identify if there are solid grounds upon which an appeal can be mounted. That process is still underway, so I'm not able to engage on a blow-by-blow account of pointing out the grounds that we can rely upon.
And what, tone are you taking with you as the National Prosecuting Authority to meet with the Free State, officials? And I ask this because when you listen to the judge earlier on, he speaks about the fact that, the extradition order would have been clear as to which cases she would have needed to answer to. But to his surprise, and all the charges she was then made to plead to, which he says that it boggles the mind. And now you think about the fact that there's, of course, a lot of fingers that are pointing to the NPA right now as to how then did things go wrong here. What then is the tone that you are taking as the national officials to your Free State counterparts tomorrow?
When the argument was presented to Bongi by our prosecution team, and the issue of the 8 charges being put to Ms. Cholota instead of 4, our prosecution team was candid enough to concede that it was an oversight on their part to put all 8 charges when in circumstances where they should have put 4. I think we should give it to them to actually commend them from being bona fides, being frank and clinical enough to concede that it was an oversight. So we accept that.
But do you also accept the fact that the state says, that the judge says, and I quote, the state should have made certain of its facts. I agree with the submissions to the effect that the state would provide false, incorrect information to the authorities of another country concerning a South African citizen presents a serious public interest concern and has serious implications on the interest of justice. I also agree that the conduct of the state grossly infringes on international law and constitutional law.
That is exactly the part or some of the contents of the judgment that the NPA is currently reflecting on. And between now and tomorrow, a possibility exists that a decision will be taken in respect of any solid grounds that would have been identified upon which an appeal could be mounted.
So, Advocate Shabila Batoy, how is she reacting to all of this? And what does she say to South Africans who are saying that it does not look like under her leadership the NPA is actually doing what it's supposed to?
The National Director is equally concerned, as we all are, with the perception and the impact that this could have on how we are handling these high-profile matters. However, we appeal to the public, including the media, to be very cautious in prematurely pressing a panic button, given the fact that the judge and throughout the trial, within a trial of the special plea raised by Ms. Cholota, the issue of the merits of the case, the strength of the state's case was not ventilated, pronounced, or adjudicated, nor does it have a bearing on the case that is resuming tomorrow against the other accused persons.
So you're confident in the case that resumes tomorrow that you will be able to successfully prosecute these individuals in the asbestos matter?
Evidence that has been presented to prosecution by law enforcement, upon a careful assessment and examination, evaluation thereof, a conclusion was made that the charges preferred against them when the trial resumes tomorrow will be sustained.
As a final question, you heard one of the accused, that's Ace Magashule, saying that the state has in fact hidden the recordings of Moroadi Cholota. They would have, interrogated her. She would have been interrogated for 2 days. The recordings would have been there. But now there are claims that the recordings were not working. And he also claims that he's going to be shocking a lot of people here because he says that this matter is quite political. How do you respond as the NPA?
I'll respond to this, Bongi, in 2 ways. One, I am constrained by the ethical rules of the bar that an advocate like myself, who's a lawyer, cannot wrestle in the media with an accused person in respect of a pending litigation. However, I need to point out that our focus is on the judgment that was delivered today, and none of that came out throughout the judge reading or delivering the judgment. And as such, I don't think I need to add more to what I have just alluded to.
Advocate Tim Tunzimaka, let's speak tomorrow then to see how that meeting you have with your Free State counterparts actually does pan out. Appreciate your time. That was Advocate Tim Tunzimaka, the NPA's national spokesperson. When we come back, we take a look at this issue at a deeper level with some legal analysts. All right, let's continue then with this matter around the extradition ruling earlier on in the Free State High Court there around Moroadi Cholota, who's the former personal assistant to Ace Magashule. We speak now to legal expert and director at Durban Attorneys, that's Ntabiseng Durban, as well as legal analyst Melusi Ulu from Donda Attorneys, who are joining us this evening. A very good evening to you both. Thank you so much for your time. Ntabiseng, let me start with you. Your reaction to the ruling?
Well, pertaining to the way in which the accused from the onset was very, emphasizing the fact that her extradition was not correctly done, it was very interesting to see how her attorneys presented the case, how the process was not exactly followed. I understand my colleague who was on the NPA side just now talking about how the ruling was not in place at the time that the extradition process had started. But unfortunately, or should I say fortunately, they were aware that this is the situation that's currently happening. The matter is on appeal. Perhaps they ought to have aligned themselves with the possibility of this situation happening. But be that as it may, it seems that the accused line of defense, in that her extradition was not correctly conducted or correctly done, she was vindicated today, and therefore her being found that the extradition was not done correctly, it means her arrest was unlawful. It therefore means automatically the charges have to be withdrawn because we now have to align ourselves with Section 35 of the Constitution. So,
Ntabiseng, before I move to Melusi, I want to stay with what you said, right, around the judgment, the Schultz judgment, that is, because when you listen to the NPA, it says that the Schultz judgment was not in place at the time. And the judge earlier on was speaking about the fact that they would have had 2 months in order to be able to engage the Minister of International Relations and work on this particular matter, because the judgment is clear on who has what power and what authority. Can it be a successful appeal process should they decide to use this as a grounds for appeal?
I don't exactly remember the exact wording of the case that states that the minister has to give some kind of permission. If it applies retrospectively, then they would not have any grounds whatsoever in terms of appealing, because then they would be bound by the judgment. But if there is no retrospective application of the judgment, then it's likely they may have some kind of ground to stand on. But be that as it may, when we look at the previous matters that we've seen that deal with extradition, not only is the Minister of Justice involved and they have a say in what is supposed to happen, the question is, was the minister as clued up in this particular case versus the other matters that we've seen that are currently happening, which are still unfolding in the different courts? And if we look at the kind of what is this? The court process that are happening, for example, is it the Bushiri case? No, it's not the Bushiri case. The other pastor who's now...
Well, with Nandi Pamakutumana as well now launching an appeal.
Yeah. So what usually would happen is that the country, the host state that has the accused would be informed that, listen, Ntabiseng is wanted in South Africa for crime X, Y, and Z. And then thereafter, Ntabiseng in country that is hosting her would then inform her that this is the situation and detain her per the agreement between the two states. Yeah. And then in that particular country, a hearing is held there to determine whether or not she can be brought back this side, which is what we are seeing unfold in very many extradition cases. In this particular instance, it doesn't seem like that particular process was followed, or if it was, not completely. And therefore, it led the court to say that in these 2 months, what did you do to fix the situation, which it seems like you haven't done as the NPA.
So, Melusi, when you look at what the court had to say, and I'd like to borrow from some of it, the court saying that what appears pertinently clear is that the state presented false and incorrect information to U.S. authorities. U.S. authorities relied on this information in good faith and ordered the extradition on an unknowingly unlawful basis. How damning is this?
Good evening to you, Bongi, and to my fellow guests and to the viewers at home. I think it's very damning, as you put it, because it shows that, the state had to use, wrong ways of getting this extradition. It reminds me of a case that I was just looking at. It's Olmsted versus the U.S. It's a U.S. case where it states that if the government breaks the law, it invites anarchy, it makes the people to have a contempt for law, and it also makes the people to disregard the law or take the law unto themselves. So we rely on the government, Bongiwe, to ensure that the right processes are followed in everything, including extradition. And what we must remember is that extradition is to ensure that an accused that we want from the requested state is brought into the country. But also very important, and I think this is what the state must look at, especially the NPA and every stakeholders involved. They must also protect the rights of the accused who are being extradited, which means the right to dignity and the right to freedom and security of person is also important for the accused, to make sure that the right procedures are done and their rights are respected. They are constitutional rights. So I think what we are learning here is that even in the state, they must still apply the constitutional rights of the accused.
So in light of that then, Melusi, right, we heard the state, in court, in fact, the judge saying that the state informing the court through an affidavit of one of the investigators that the fact that Moroadi Cholota did not attribute certain instructions to her former boss, which was Ace Magashule at the time, as a result that now she was then treated as a suspect and is going to be facing the same charges. And she, in the matter, the special plea, had said that, in fact, this was a threat because she wasn't cooperating. And now the NPA saying that, but this was simply a fair warning, as appears in, the bail proceedings, and for them, it was just a fair warning here. So does that demonstrate a protection of these rights you're talking about?
Yeah, look, I think if you are being extradited, or before an extradition is made, let's just put this logically. They are requesting you to come and be a witness in a case in South Africa, but for some reason you refuse. And then they say if you don't cooperate, they are then going to arrest you on this particular case that you must be a witness in. So I think in that regard, it shows that the state was actually using threats to get whatever they can from Ms. Cholota. And then at the end of the day, they then use false information to get an extradition. And then there was a Hollywood kind of scenario where she was brought back to the country, only to find that months later they will withdraw the case. And on a special plea or trial within a trial, she has now been successful in showing that the extradition was not done properly and it was unlawful. So for me, Bongiwe, I think her rights were not respected and her rights were not protected. Like I said, what is important is as much as you're having an extradition, but we must also protect the rights of the accused that is being extradited.
So Ntabi saying, if you then hear from the court, right, that the prosecution conceded that she should not have been required to plead to all counts because it was very clear on the order what are the counts that she was supposed to have been facing, and the court saying it remains a mystery as to why this was done, one wonders what becomes the implications of some of, especially here, should the NPA decide to then appeal this particular matter. Can they say that this concession demonstrated good faith somewhat and an oversight, as has been said?
I do not think that it would be afforded that opportunity to be viewed as a way of protecting the witness's rights, or in this particular instance, it would be the accused, because she had to come here and face 8 charges. And our colleague just said from the NPA that she was not supposed to face 8 charges, but only 4. So now, as a result, we are now looking at Section 35 of the Constitution, which protects the rights of not only arrested and detained persons, but also suspected persons. If the state was indeed in need of her evidence in order for them to proceed with the case, the correct process, apart from the extradition, would be that in a normal criminal setting, it would be that when it's her turn to come and give evidence, then a subpoena would have been issued, and then she would come and give evidence. And if she failed to come, then a warrant of arrest would be issued for her to come and appear. And when she fails to appear, she'll be in contempt of court. Now we have grounds or basis for her to be brought back into the country because she failed to adhere to a court order, which is the subpoena that's asking her to come back into the country. So now anything that she has given after she was brought back here. So any viva voce evidence, any statement that she has ever done has now automatically been deemed unconstitutional. I just forget the particular case though that was held just before the constitution that we have now was made final, while we still have the previous constitution wherein Judge Chaskelson, I beg your pardon, said that even the suspected persons, when they find themselves giving statements prior to their rights being read to them, or in terms of section 218 or 219 of the Criminal Procedure Act, if it is found that everything was done against the Constitution, therefore everything would fall away. So anything that she has said cannot be considered by the state anymore as a result of this current case.
So, Melusi, what bearing, if at all, does this have on the ongoing matter around the asbestos case? In fact, it goes to court again tomorrow.
I think if you check the statements by the NPA, they've stated that this does not have any bearing. But what we know is that she was going to be a key witness initially, and then she was then arrested. So in any case, she's now, or she was an accused. So they've stated that the other accused, which will be starting tomorrow, resuming tomorrow, the case will continue. So in their view, there's no bearing, and they'll continue with the case, which they believe is strong enough to get a conviction, I suppose.
And I'm going to ask both of you this question. I'll start with you, Melusi. How does the NPA begin to clean up this mess? And I ask this because we've seen what has been happening in the public domain with some high-profile cases. So where do they begin?
Look, if you go to Section 2, and my colleague will also agree, of the Constitution, it says the Constitution is the supreme law of the country. Any act or any law that is contradicting the Constitution is invalid. So what the NPA needs to do is that even though the case is high profile, even though the accused that they may want to arrest is a person that they believe even the public wants them to arrest them, they must not be led by emotions or try to get the case banged down at all costs. They must still respect the Constitution. And if they do that, they will make sure that they don't make mistakes in their cases, because we know there are other cases. Currently, the Makutmane case might go to the Constitutional Court. In fact, it's gone to the Constitutional Court. So we will see how that will be done in terms of looking at the optics of how the NPA is working, including other high-profile cases.
For you, Nthabiseng?
I agree with my colleague. It seems like things are rushed and unnecessarily so. We need to make sure that the investigations are done thoroughly, that if you're going to call witnesses, you prepare them in advance, so that you know by the time you place this matter on the roll. We're not dealing with postponements for lack of witnesses coming. We're not dealing with postponements for lack of evidence that is there. So as a result, I would suggest that when it comes to just such high-profile cases, make sure your ducks are in a row, so that when defense attorneys come in, they're not saying, but you're missing this, you're missing that, and then you're making representations and saying, but you do not have a case against our client. So if all the T's are crossed and all the I's are dotted, it makes it easy for the state to have a prima facie case against the accused and most likely be able to convict the accused persons.
Let me thank you both for your time this evening. Appreciate it. That was legal expert and director at Dubazana Attorneys, Nthabiseng Dubazana, as well as legal analyst Melusi Ulu from Donda Attorneys. Let's take a look at some of your comments tonight. We're asking you, do you think the NPA can successfully prosecute the accused in the asbestos case? Siabulela saying good evening, Bongiwe, and good evening to the viewers as well. If you can please bring back that tweet there by Siabulela, as he was, of course, talking about this particular matter. Let's take Kuto in the meantime. Kuto saying, to save face, the NPA must withdraw all the charges against the accused. This is clearly political, and they will be embarrassed again if they insist on prosecution. Siabulela saying, good evening, Bongiwe, and good evening to your viewers. I can only wish the NPA fails to prosecute simple cases with tangible evidence, such as the state versus Omotosho. Some of its prosecutors were not yet born when Amsdale case went to court. No success there yet. Same story here. Dennis, the NPA will need to carefully consider the judgment and potentially appeal to move forward with the case against Cholota. The outcome will depend on the NPA's next steps and the court's decisions. Rabotata, the NPA is really messing the cases. Omotoso was acquitted due to inability to handle the cases. The acquittal of Cholota is a precursor that the asbestos case will be thrown out of court. All right, do continue to keep some of your comments coming tonight as we are looking at whether or not do you think that the NPA will be able to successfully prosecute the accused there in the asbestos matter. It goes back to court again tomorrow, but there is another developing story that took place earlier today, and this is around the developments on the MK party. We've seen the now outgoing Secretary General Floyd Shivambu, who is now going to be redeployed to Parliament. What implications is this likely going to have for this political party? Did they handle it correctly? Levindo is on standby to talk to us about that. The MK party has decided to redeploy its Secretary General Floyd Shivambu to Parliament. The party making the announcement at its media briefing in Durban today. Last week, Colleen Makubele succeeded Mzwanele Manyi, who was removed as the chief whip of the MK party. Shivambu has welcomed the redeployment. Let's look at what this all means now with political analyst Dr. Levindo. Good evening to you and thank you so much for your time. Was this a good move?
Good evening, Bongiwe. Good evening to the viewers at home. Well, I think it was a good move. There was speculation throughout the departure of Shivambu from the EFF to the MK party. Most people indicated that it's not going to stay longer in the party and specifically in the position. But I think what the MK party did was to say, because there could be a huge or a much bigger impact if it's totally removed from the party, they opted to take it slow or soft and not necessarily remove him from the party, but redeploy him from the party to Parliament. I think this was done to ensure that the attention is diverted from not necessarily talking about him being removed from party leadership, but we therefore talk about him being redeployed to the National Assembly. And my view is that when you have been at the helm of the party and you're actually being removed in the manner that is being removed, I would classify that as a demotion.
So now, when you look at the fact that right now we just saw Colleen Makubele now being, put in the position of being a chief whip, and now there is Floyd Shivambu. Some have said that this demonstrates a pattern of instability and some governance issues, that leadership positions may be changed overnight. What's your assertion to that?
The MK party arranged a number of gatherings. One of those was to adopt the constitution of the party. And what they've agreed upon as a party is that they are not going to have elected representatives. They are going to opt for appointing representatives in the structures of the party, including deploying them to different legislatures or government structures. So anyone who is joining the MK party should go there being aware that at any given time, they could be redeployed or they could be removed. But also, it could have been a calculated move that when they decided to remove Shivambu, they had to do it at a time when there are good reasons to do so. What they did was to look at something that people will say, indeed, in this case, the MK party has considered the views from their structures, the view from ordinary citizens who are saying that the decision by Shivambu to go and meet Bushiri is miscalculated, it's against the constitution, and it brings the party into disrepute.
So it sounds pardon me, it sounds like you're saying that it was a long time coming.
Indeed, it was a long time coming. If you look at a number of media reports and the relationship that Shivambu had with some senior members of the MK party, it was long coming, and they actually waited for the right time to do so. And that is why in the last few weeks, there were reports, and there was a letter that was leaked, and in which the MK party denied that it comes from them, that was talking about Shivambu being redeployed. 5 days after that, it is confirmed that indeed Shivambu has to be redeployed. So the only thing that we're waiting for was the right time for the party to act, and they actually decided to act today.
So when you look at, the party and what it has done at a national level in terms of the movements, but Why does it seem like they're not dealing decisively with what is currently happening in Mpumalanga with Busisiwe Mkhwebane and Mary Phate?
I think it will depend on the dynamics surrounding the situation in Mpumalanga and now with Floyd Shivambu. In Mpumalanga, it is very clear that there are parallel structures. It appears as if there are two organizers in the province, Mepadi and Advocate Mkhwebane. And unfortunately, the party appears to be moving slowly in dealing with those matters. But with Shivambu, there are things that they wanted him to do and which he successfully did. To deal with running the office of the Secretary General, to deal with the matters of the Constitution, and also to ensure that there are structures that are in existence of the party beyond KwaZulu-Natal. Shivambu has been able to do so. And now that his task is done, I think they got the right time for him to be redeployed.
But what implications, if at all, then, can it have, can the developments in Mpumalanga have on the party? And I ask this because, like you've just said right now, that they seem to be moving slowly in dealing with that particular issue because we've seen what has been taking place in the public domain. So what does that say, number one, to the MK party voters, but also to some of those who potentially could have been looking at this party as an option?
We could be worried that the MK party could be moving slowly in Mpumalanga. What they could be doing will be to assess the situation in Mpumalanga, look at what could be the best option that they can adopt. They might be deciding not to act very quickly because they have to read the mood on the ground. Then if they act quickly at some point, it might have its own implications. So they could be starting to read the situation on the ground, listen to their constituencies and structures, and then take the right decision. In case of Shivambu, they say that their constituencies have raised concerns. They said there are many organizations, even outside the MK party, that raise concerns about Shivambu, and they felt that if they do not act, they will be perceived as a party that does not listen to the concerns of other people within and outside the party.
He's going back to an institution that he knows all too well, has spent a lot of time in Parliament. But what does he bring to the House now?
He has been in Parliament for quite some time. And whilst he was in Parliament representing the EFF, he was the chief whip. And in this case, he's not going there as the chief whip unless there could be changes that can be made by the MKP. We don't know how the party decisions are taken on members of Parliament by the MKP. We don't know as to whether he might get the reception that he could have received if he was not just redeployed from the party. We also do not know the kind of relationship that he could be having with the other members of the MP, whether they are going to receive him warmly or whether they're just going to isolate him and then he becomes a loner in Parliament. But it will require him to be able to do something about that, to ensure that he's able to fit in well, but he should be very, very careful about how the people that he relates with, because it might also have its own negative implications.
All right, Dr. Ndou, appreciate your time. Thank you so much for chatting to us. That was our political analyst, Dr. Levi Ndou. When we come back, we answer the question as to whether or not South Africa is on the brink of a full-blown water crisis. Thanks for staying with us. There are fears that South Africa is on the brink of a full-blown water crisis. Aging infrastructure, weak governance and underinvestment are some of the factors creating a perfect storm. Now, across the country, residents are also facing dry taps and unreliable supply. Last week, the department announcing that the phase 1 of the Lesotho Highlands water project is complete after maintenance work. And at the same time, the city, in fact, Joburg residents experiencing water outages due to Rand water maintenance. So let's take a look at this particular issue now. We're joined by the Director General of the Department of Water and Sanitation, Dr. Sean Phillips. Dr. Phillips, good evening to you. Always a pleasure to have you on the show. So is South Africa on the brink, and I'm going to start with that question, on the brink of a full-blown water crisis?
Good evening, Bongiwe, and good evening to all the viewers. It's a simple question about a very complicated issue. If people are experiencing water supply disruptions in certain areas of the country, and if they go without water for days on end or for weeks on end, then it is a crisis for them. But generally speaking, across the country, the supply of water is roughly in sync with the demand for water. We have enough water in South Africa, except for particular localized areas where there's deficits. Currently in Gauteng, the supply is occasionally not sufficient for the demand. And in eThekwini and surrounding areas, the demand has also been exceeding supply.
Yeah.
Nationally, we're not reaching a situation where as a country, we're going to run out of water. But water is much more complex than electricity. There isn't a single water grid. We have more than 950 different water supply systems in the country, and they're not connected to each other. So when there are supply problems in one area, it doesn't mean that the same supply problems will be in another area. Water is a very localized issue, and the reasons why there might be problems in one area will be very different to why there'll be problems with water supply in another area.
Now, from the department's point of view, would you say that the systems that are currently in place are being managed properly?
You have to look at water supply from two perspectives. Firstly, from the raw water perspective, and secondly, from the treated water perspective. The national government supplies most of the raw water through the dams that are built by the National Department of Water and Sanitation. Those dams and related infrastructure are generally in a good condition. Our audited infrastructure condition assessments of the dams found that more than 80% of them are in a good or fairly good condition. The situation is very different at municipal level. In terms of the Constitution, municipalities are responsible for water service delivery, which is about delivering treated water to residents through water storage and water distribution systems. There, the picture is very different. In many municipalities, the condition of the infrastructure is very poor.
So when you look then at the issues around maintenance, some residents have had quite a lot to say about this. And I wonder from the department's point of view, with the maintenance that's currently been conducted, how much of it, especially when it comes to water supply issues in some of the areas where maintenance is carried out, is as a result of aging infrastructure, years of neglect, as some are claiming, as well as also making sure that infrastructure remains intact so that there aren't any problems in the future?
Currently, Rand Water has been doing maintenance of some of its infrastructure. And as you know, Rand Water is the main bulk supplier of treated water to the municipalities in Gauteng. Rand Water's infrastructure is generally in a very good condition. It hasn't been neglecting maintenance. But the reason why Rand Water's infrastructure is in a very good condition is precisely because it has been doing the kind of planned maintenance that it's currently been doing, which is causing some water supply shortages in Gauteng. It's very necessary. If Rand Water didn't do this maintenance that it's doing now, its infrastructure would deteriorate. And the reason why many of the municipalities' infrastructure has deteriorated is because they haven't been doing the kind of maintenance that Rand Water is currently doing.
And I know that, of course, there is that white paper now that is, looking at dealing with some of the issues at municipal level. But I wonder, from what the department has done, because we've also seen you as a department in some of the cases acting very tough against some of the municipalities, are you finding that it's generally an issue of a lack of leadership, poor governance, or simply people not knowing what to do?
Our analysis is that there are institutional problems, which are the main underlying cause of the general decline in performance of municipalities. And that is that water is supposed to be financially self-sustaining in South Africa. Municipalities are supposed to run water and pay for the maintenance and operation of water from revenues from the sale of water. It's not funded from any other source. When you pay income tax or when you pay VAT or when companies pay tax, That money, tax money, is not supposed to be used to fund water, to pay for the maintenance and operation of water infrastructure. It's revenues from the sale of water which are supposed to be used to do that. What is happening currently at municipal level is that revenues from the sale of water are not ring-fenced for the water function. So many municipal councils vote for part of those revenues, and sometimes most of those revenues, to be used for other functions, which means that the maintenance and operation of water services is underfunded. And that has resulted in somewhat of a vicious downward cycle in many municipalities, where not enough money is spent on maintenance and proper operation of their water infrastructure, which in turn results in deterioration of the infrastructure, which in turn results in increased leaks from the infrastructure, which in turn results in a further reduction in revenue, which then means that even less money is available for maintenance and operation. So we think there needs to be some institutional changes at municipal level. Revenues from the sale of water needs to be ring-fenced for the water function, and also the water function needs to be run in a business-like way, where the head of water and sanitation has full control over all the management activities related to providing the service, so that head of water and sanitation can be held accountable and can't say that things aren't happening because he or she doesn't have responsibility for certain aspects of the work, such as billing and revenue collection, or such as supply chain management or recruitment.
Dr. Phillips, appreciate your time this evening. That was the Director General of the Department of Water and Sanitation, Dr. Sean Phillips. We've come to the end of the show. Thank you so much for watching Face the Nation. Good night.